I realized when preparing for the panel this morning that this was a Dutch panel very much because of your affiliations. So we are welcoming Catalina Goenta, who is an assistant professor in private law at the Faculty of Law at Maastricht University. At the same university, Jerry, who is an assistant professor at the Department of Data Science and Knowledge Engineering at Maastricht University. And so, too many times someone tried to say my name not the right way, so I'm not going to do that to you. Could you please just tell me how to pronounce your first and last name?
For the English speakers, it's Marietje Schaake.
I love that you have an English version. I do the same. I say Thibaut.
It has to be that way. It has to be that way. Otherwise, people are like, what?
And how are you saying it?
In Dutch?
Yeah.
Marietje Schaake.
Okay, see, I still need to
I think
learn.
I convinced you.
But so, in any case, what I do know is that you are an international policy director of the Stanford University Cyber Policy Center and international policy fellow at the Stanford Institute for Human-Centered AI. You also served as a member of the European Parliament from 2009 to 19. So very excited to hear your thoughts about market surveillance and for you to share your experience. But so without further ado, Catalina and Jerry, the floor is yours. I believe you have divided your time. So please take over.
Thank you so much, Thibaut. First of all, allow me to align myself to the other speakers in thanking you for not only your vision in terms of making this project happen, but also this wonderful event that I can only imagine how much time it has taken to organize. It's really a pleasure and an honor to be in this panel here and to bring a more European dimension to some of the things that we already heard. And I am very happy that especially I'm going to try to build on a lot of the things that Carrie specifically has been mentioning, because it seems to be the case that when we're speaking about the computational antitrust, or what I'm going to try to imbue in this presentation, the more consumer protection perspective as well. So you can have computational antitrust and you can also have a computational consumer protection. At the end of the day, it means the same thing. You're trying to look at digital markets and trying to understand what exact violations can be detected, and how can the automation of these violations be detected and actually pursued. So what Jerry and I have prepared for today is a discussion of a paper that we also have upcoming in the series that you are so completely unique in governing right now at Codex in the Computational Antitrust Project. And what we're going to try to discuss today is, first of all, try to think a little bit about the idea of market surveillance and the concept of digital enforcement, try to define that from a terminological perspective with some examples from European public policy. And then what I'm going to do is also take you on a journey through an example of how digital enforcement looks like currently in the European Union by taking you through the CPC regulation, the Consumer Protection Cooperation Regulation, and giving some examples of powers that authorities have, and also making a bridge to what Jerry's going to present, namely the idea of how exactly to put these powers into practice through technology by focusing on the pros and also the cons in terms of also what Carrie was mentioning earlier, the idea of putting these technologies or the deployment and the development of these technologies in private hands. And we're going to conclude with some questions for debate, which hopefully are going to also fuel the conversation and the discussion with Marietje. So what we, perhaps even before going into this context and terminology, also an anecdote, because I know Thibaut, you like anecdotes. So I was sharing this event on Twitter a few days ago, and basically also with the title, The Idea of Legitimacy and Market Surveillance. And I remember there was a comment and someone said, wow, that sounds really creepy. Well, it definitely doesn't sound as creepy as what Carrie was mentioning in terms of predictive policing. So all of the algorithms that are being used in the criminal justice area, or some of the examples that we also had in the Netherlands with more social policies and the detection of fraud, for instance, in tax or social subsidies. But actually, if you think about market surveillance and the history of market surveillance in the Netherlands, I think that this is one of the least controversial, if we may say so, topics that are going to bring with it the question of how do we detect things, what kind of harms do we want to focus on? And that is mostly because of the fact that when the internal market was created, the idea was that the actual freedom of movement of goods and services brought with it a responsibility to make sure that the kind of goods and the kind of services that were offered on the internal market were safe, that they were somewhat that they would be safe as consumers would expect them to be. And this is something that Monique Gooyens, the director of the European Consumer Organization, also emphasizes in her scholarship, the fact that actually consumers in Europe expect that when they go and they try to purchase a product or when they go into a store or get a service, they expect that to be safe. And the safety is actually the main goal of market surveillance, as we have it also defined in a new framework. So there's this market surveillance regulation from 2019 that also reformed perhaps years and if not decades of prior market surveillance activities at policy level in the European Union. And as you can see, that the entire idea of market surveillance that we have in the European Union law relies on the idea of product safety, the fact that products should be made available in a safe way, and that we shouldn't be able to engage in transactions that don't do that. Now, from this concept of market surveillance, which has a long-standing history of legitimacy, which we actually discuss in greater length in the paper, we go to the concept of digital enforcement. And we have seen that in the AI white paper that the European Commission wrote or came out with last year, in the AI Act, we see so many references to the idea that digital markets require digital enforcement. So from this perspective, digital enforcement has this dimension of a broader meaning that does not only entail product safety, but it entails several narratives, and we can find some also in the work of Margot Kaminsky. For instance, this idea that whatever is available on the offline world should also be available on the online world in terms of redressing harms and kind of taking notice of harms and redressing harms that occur. Of course, we also have a different narrative because there are some harms that might be specifically kind of intimately native to the digital markets. And this is why even this concept of digital enforcement right now has a little bit of an identity issue. But basically what we try to do is to clarify it and to say that it is broader, and it is a trend that we see in European public policy of doing enforcement on digital markets. An example of such enforcement we can see in the Consumer Protection Cooperation Regulation, which entered into force last year. So now it is one of the most important sources of power for authorities in the European Union that are trying to look at, for harms that are affecting consumers specifically on digital markets. And we see that it focuses on 3 categories of infringements. The tests for these infringements are highly complex. But let me just take you through, for instance, an example, intra-EU infringements, the idea that we have infringements that happen within the European Union, but there is this kind of transnational dimension of that infringement. Or another example, the widespread infringements. You can see that there is a calculation even of how many member states need to have been affected by a specific harm, which can be a past harm harm, an ongoing harm, or a likely harm, and that harm needs to be detrimental to the collective interests of consumers. So this is not my role here today is not to really take you through the nitty-gritty details of this regulation, which as I mentioned earlier, is highly complex, but to give you some examples of why it is important, and that Jerry is going to build on with the questions, with the more normative questions that we have in our paper. So this regulation actually really reforms a lot of the powers and gives more grit to the powers of consumer protection authorities, which in some jurisdictions are the same as competition authorities. For instance, it actually formalizes a right to do mystery shopping. So any kind of authority can go and try to promote, to try to purchase goods from a specific, let's say, e-commerce website, and then look at what the results are and what kind of violations the outcome of that type of mystery shopping will entail. So this is an example of investigation powers, and we also have the so-called enforcement powers, which here in a way compensate for perhaps at least 2 decades of less effective regulatory frameworks, as this is also in consumer protection literature. This is something quite generally acknowledged, that traditionally speaking, for instance, for digital markets, the enforcement of consumer protection dealt with a lot of legal uncertainty, and therefore was often basically brought up as being ineffective. However, now the doubling down on what it means to have effective means for the situations of these widespread infringements, the 3 categories of infringements, actually, you can see some examples here, such as the idea that an authority has the power to remove content or to restrict access to an online interface, which is huge. It's really something that gives authorities a lot of leeway in dealing with rogue traders, and an example of that is what has been happening in France just a few weeks ago, the way in which French consumer protection authorities have been using these new powers. Basically, they have used them against a company that is based in San Francisco, actually, Wish.com, and that is because they have done this mystery shopping and noticed that a lot of the products actually posed a lot of harms for consumers because they did not comply with, for instance, labeling, or they had perhaps ingredients that shouldn't have been on the list of ingredients, and this has been a problem. So this is an example, a very recent example of how the French consumer protection authorities have made use of these powers. Of course, the thing is that also, if you read the entire press release, you can see that the investigation that has been done has not been an algorithmic investigation. And what I'm going to do is pass the floor to Jerry and discuss the potential and how perhaps these kind of investigations could be scaled up as an example of what computational consumer protection can do, and how that can also inspire perhaps computational antitrust. Jerry?
Yeah, thanks, Catalina, for taking the lead on this and the presentation and the paper. And thanks to Thibaut and his team for this wonderful event. I'm happy to be here as well, also joining a panel where people have weird names. That's why I'm going with Jerry, which is not my original Greek name, but just my also international name. So in our paper, we're discussing the context of digital enforcement and automating it, and how it should be done and by whom. And here what we are debating is exactly the different consumer and competition authorities. They are all eager to use technology and in different ways. However, what we also see and mention in the paper, based on the work of Mulligan and Bamberger, is that what we see usually in these cases is a procurement mindset instead of a policy mindset. What we mean by that is that most, let's say, state agencies, administrations, they just try to contract technical systems that might employ some kind of technology, could be machine learning or anything else, And exactly in the end, what happens is that government relies on exactly this technology, which comes from private parties. And of course, nobody can blame them on a first take, just because, of course, they're not technology leaders, or they have no resources, and they have to rely exactly on what is out there in order to provide this automation and these solutions to the public. And exactly the one of our, at least mine, but also Katarina's criticism points is that exactly the emphasis goes on tools, and we usually quote that because exactly people use tools in a way that there is this magical wand that can fix anything, right? So anything can be a tool. However, is that really right? And should that be the focus on let's get something today that might not work tomorrow? Is that the right tool, and so on? And of course, one of the other challenges is exactly the resources and priorities of consumer competition authorities, which are, of course, very limited, both in terms of course, financial resources. It all comes down to that, but also into knowledge and technology resources. So the question we are here asking ourselves, but also you, is who should design these computational frameworks that exactly do not yet exist? And should we just rely on the private sector and all, let's say, the industry actors that are taking the lead on this? Should the public sector take also a role in that, even with the limited resources? And of course, what is the broader role of academia here? Academia is a great partner for many different reasons. First of all, because we are knowledgeable about what we're studying, but also because we're not profit-driven, so we're really driven about what and how things should work. And here we mentioned the example of dark patterns, which is an example of let's say, digital enforcement project and how that can scale up. And it was led by an academic institution at Princeton University. Moving on and what we want to stress is that we have these needs not for tools, but for a technological framework that can work today and tomorrow, and then we can discuss how that can be specifically implemented. That goes a bit also to, I saw the presentation of Kari about, what is a technological framework and how we can put machine learning and AI into use. So what we need and we propose here is exactly investing in people and infrastructure, right? If you want a tool today, that's great. It might do your work for the next month or so, but then technology moves very fast, so you might be very, very well outdated with something that was built today. Instead, investing in people and being able to exactly go past this procurement mindset, it will give you the room to have technology that can work at any point. And the focus here we're going to put is exactly on what should be this framework, what should it include, not just technological solutions, but also focus on transparency, fairness, and accountability. And usually we try to shape that around three pillars, right? About what kind of data do we want to utilize? And should this data be used? Who should decide what data should be used in this case? What kind of algorithms and model we want to utilize as well. Sometimes algorithms by themselves, they're not going to give us a solution because exactly they rely on the data we use. And finally, and that goes a bit also to exactly how we want to scale things perhaps, and exactly what we want to do is how do we evaluate this approach and how do we measure the outcomes. And here we have just a screenshot of the dark patterns repository on GitHub, which is open source, as was mentioned before. Open source is, I would say, the way to move forward. It's also what we are, educating our students these days. So this is the mindset we to develop. However, it does come with challenges, right? So this is a public repository. It can be used and picked up by anybody involving researchers, but also consumer authorities. However, having something which is open source means that also needs to be maintained, and this also needs additional resources. Moving on to the maybe to start also triggering you a bit about the discussion, is that what we've maybe experienced so far is that exactly businesses, and you can imagine anything here like a retail business, an airline, or anything else, they just been profiling consumers, right? We all know that, even if we exactly not aware of it, that we've been somewhere a data point at some recommender system, that somebody was trying to exactly monitor our consumer behavior and try to recommend us new products, or try to persuade us to buy new products, or show us relevant advertisements. We've seen all these stories many times. At the same time, the state is at least monitoring and trying to go into this surveillance of citizens. Especially in the context of COVID-19, I'm pretty sure you're aware that different states and different governments try to implement all this mission impossible of vaccination in different ways and different forms, let's say, of digitization. And of course, this government digitization goes, can go a bit deeper about, what is our relationship with administration. So what we see now, and what we have seen what we've seen happening already, is that there is this triangulation here, right, of, on the one hand, businesses monitoring and profiling citizens for different reasons, right? Social media is a very good example here about how they were used in a way completely different context than they're supposed to. And what is the challenge here, and what we want to raise as an ethical point of view is what if state starts implementing this massive surveillance operation on consumers just in the sake of digital enforcement. So what we want to say here is that exactly how the surveillance should be set up in a transparent way, so that consumers are not harmed. So just to summarize a bit, and also trigger a bit questions for debate. Here are 4 questions that we have in our minds, and we would like also to hear the opinions of course, Maricia, but also the audience. Is that, first of all, exactly how this policy mindset will be in practice when it comes to designing, but also applying computational enforcement. At the same time, how we defend and we protect, first of all, of course, government agencies, but also consumers from snake oil risks. If you don't know the term snake oil, which was introduced by Arvind Narayanan, you can just Google it up, or very simply, we talk about approaches that promise something that is not really there. I would say that most of the approaches around that call themselves artificial intelligence tools these days might fall under the snake oil category. At the same time, I talked about transparency and the role of it in the whole design and implementation of these administrative procedures, how that should be integrated but also implemented. And finally, again, right, the concerns of this operation. How can we make sure that the weaker parties and, of course, consumers are protected from increased surveillance and maybe extreme powers just because we're implementing this monitoring? And I think with that, we are done, hopefully on time. And we're looking forward to the discussion.
Thank you very much, Maricia. It's going to be very easy for you to answer all of those questions, which are just tiny questions.
Right.
But I'm very much looking forward to your comments. So the floor is yours. And
Yeah.
I will just say that we will then, of course, address the questions in the Q&A. So feel free to enter more questions. We have quite some time for discussions, as we have half an hour remaining.
Thank you very much. And congratulations to Catalina and Jerry for their very thought-provoking paper. I have to say, I didn't know we were all having a Dutch connection, even though it feels to me that we're a very international team, but it's very nice to have such a Netherlands-anchored crew at Stanford, because it connects two of my worlds. Anyway, indeed, a lot of questions. I'm not necessarily an antitrust expert, but of course, antitrust is a very foundational principle for fairness in the economy. And so everyone who's ever thought about tech policy, as I have, or who has been a member of parliament, has thought a lot about antitrust and also how it's applied. So my comments will probably come more from an applied side than from a research side, but I hope that they can contribute to your thinking as well. So on your first slide, you spoke about legitimacy, and I think that that is really a key question. Not only in terms of, who has the authority to apply oversight today, but also what might we be missing? And are there questions about whether companies, for example, have the legitimate mandate to assert as much power as they do to monitor behavior and to engage in surveillance? So I think what really helps also to clarify some of the questions that you ended with regard to protecting the citizen from undue surveillance versus, legitimately mandated surveillance, is to ask yourself, who, and this is in the context of a law, so who can legally know what, and also who benefits of that. And this may also be a little bit of a remedy against all the snake oil, right? Sales pitches and so on, tech utopianism. So to put an example on it, surveillance is creepy when data is hoovered up by big companies or when it's repurposed, or perhaps we actually need more surveillance of big companies in the interest of protecting consumers / citizens. And I should add, and I think you make that clear in your paper too, that monitoring the market is a normal part of compliance. Think about checking whether goods on a ship are properly cooled, or whether they meet the quality criteria that apply in a certain market, or the safety criteria when protecting children or passengers in cars, for example. So monitoring goods is very normal. And some of such checks and some of such monitoring can be done with the naked eye, or information can be deducted in a lab. So let's say you have a drink, you don't know exactly what's in it, you put all kinds of testers in it, and you can assess whether the company has been compliant and so on. But trade and economic development has gone from goods to services, where there's much more to monitor in the chains of commands, in decisions taken by leadership. Think about financial services, for example, or the emails that were also made public when they were seized from Apple or Google, when their actions dating years back were probed to assess whether their decisions made then were actually intended to negatively impact their competitors, which is also an element of antitrust enforcement. So after goods and services, data is now a growing part of trade and the economy, a larger part of the so-called market, and also a context, digitization, data processing, a context where wrongdoings in the context of antitrust and competition law can happen. And so I think one key observation here is to place your paper in a broader context, is that while consumer protection is a goal of antitrust enforcement, there are also many other methods and other criteria to assess antitrust violations, if that makes sense. So it's one slice of assessing harms, but it's not the only slice of assessing harms. So antitrust rules may actually have been violated without a single consumer having been harmed, if you know what I mean. You don't necessarily have to prove that one consumer or the other has been harmed, but if there have been price agreements made illegally, or a merger has led to monopoly forming or things like that, that can already be harmful in and of itself. And of course, with digitization and more information and data in the hands of private actors, the big question is, what do we know about the market and where is the market? So a lot of that monitoring, and I think also monitoring that you talk about, is external, if you will. It can be observed, it can be scanned, it can be scraped. But there's also a whole different side, which is, internal proprietary data processing that happens outside of everyone's purview. And I think that that is exactly where the antitrust authorities want to look, because that is actually the domain where it's much harder for a person to prove that their rights have been violated. And, to prove that one's rights have been violated is sort of a sine qua non for redress. I mean, if I cannot show that I've paid too much, it's really hard for me to show that I've been wronged, and then to claim any kind of compensation or action from the regulator. So I think the real question is, how might, in a digitized, increasingly proprietary governed context of businesses in the digital economy, how might an aggrieved party, which can be a consumer or a business, discover? And you talked about transparency, fairness, and accountability, which are, of course, major objectives of regulation in and of themselves. But then the question, I think, becomes, when we look at this frame that you are using in your paper between procurement mindset and policy mindset, will there be standards regulated for that are going to help facilitate oversight? So, for example, accounting type standards that trace algorithmic decision-making, just to give one example, so that even in hindsight, when an outcome is there, it can be traced back to what kind of decision was made, how data was processed, how people's behavior was changed, and so on and so forth. And so that also leads to questions of oversight of software. And also then, and I think this is interesting in the context of what you're saying, how will the market surveyors be overseen, right? Like, who is checking the one that's checking? Because if these are companies that are hired by a regulatory body, there will never be blind trust. And so either there have to be clear guidelines, or there have to be some kind of standards according to which companies can surveil the market, and sort of be in line with the democratic mandate that antitrust authorities have. And so I think if you had more time to work on this paper, it would be really interesting to link much more directly to antitrust law. So not just to consumer harms, but to antitrust law. And the reason is that antitrust authorities are remarkably strong. They are actually, broadly speaking, stronger than a lot of consumer protection laws because of the ability to access and demand proprietary data. So it's almost like a legal subpoena to demand for information that otherwise would remain hidden, for everyone involved. They have extraordinary mandates. And there is also work being done now to evolve those mandates, to specify the application of antitrust and competition law in the digital era. So think about the Digital Markets Act, for example, in the European context now, that is really intended to spell out even more specifically for tech companies what their responsibilities are as major market players, what is expected of them in terms of, for example, behavior vis-a-vis smaller size businesses, consumers. And so it's a really interesting and dynamic field in and of itself. So to conclude, the separation, or the two sort of mindsets that you spell out in your paper, the procurement mindset or the policy mindset, I think they actually interact with each other quite a bit. So on the one hand, regulators, including antitrust regulators, may choose to bring on board technological solutions to help them monitor and regulate. But at the end of the day, it has to be crystal clear through policy who is ultimately responsible and who sets the terms of use and who oversees the overseers. And what is important to remember is in antitrust law, which we often see as a huge hammer, right, to go after companies with, the aggrieved company, so the company against whom a case is brought, Microsoft, Google, Gazprom, also have strong rights. So the regulator who claims that antitrust rules have been violated must have a very strong case that stands up in a court of law. And so therefore there should not be and there cannot be any room for ambiguity about how the software works, what the details are exactly, and so on and so forth, because the mandate and the legitimacy of the regulator at the end of the day comes from the public. And so everything has to hold up in a court of law. And I think that that is a sort of backstop that can be helpful and that also will lead to new criteria for what any kind of market surveillance software will have to adhere to. So I foresee a lot of policy, a lot of criteria, and then possibly on the basis of that, more procurement from authorities. I'll leave it there. And I've learned a lot. So thank you for including me, and congratulations on putting together this great conference.
Well, thank you very much. And what I see is more academic papers, which makes me very happy.
That too. Yes.
With one question which appears in the chat, and this is not the first time, and that's also a question that you've been asking. And so there's also a question that I had. What someone is mentioning the irony that it would be for an antitrust agency to investigate a company using one of the tools provided by the company, right? And so who's surveilling those agencies if they make use of such a tools? There is another question in the chat which is related, is as to how do we measure the harm that could be caused by computational antitrust? And one question that I had, and you see it all comes back to the same idea, is there any example in which you will ask for the agencies to bear the cost of their analysis, right? Because it seems to me that it could be a great way for them to be very cautious. So Catalina, Jerry, if you have any thought on the subject, as to, you know, how do we ensure that we are not creating a monster, which is basically, you know, we could say, again, instead of saying fighting fire with fire, it could be fighting monsters with monsters, right? The private monsters, but maybe we do not want to create a public one. So any thought on that?
Maybe just to start, so thank you so very much, Marietje, for your really important comments, because we're taking away two main things. So first of all, the linking to more antitrust. What we wanted to do with this paper is to create also an illustration of how the same discussions about kind of computationalizing things have been happening in consumer protection. And I'm happy that you mentioned this idea that basically antitrust has been, you know, the policy sector where the enforcement of which has entailed kind of going into companies physically, removing information, removing servers, removing data. And this has been considered such a scarecrow in terms of enforcement, and it has been considered to be so effective. And so this is exactly what also inspired me to bring in the paper the CPC regulation, because I think that you can see that consumer protection has taken inspiration from antitrust in this respect. And you can see that the CPC regulation is very much also in line with the DSA, where there are these new kind of revelations about, well, how are we going to have access to the data that we need in order to audit the activities of these companies? And this is where it becomes quite the answer to the question of how do you do that in a consistent way and in a way that is transparent, I think really boils down to the actual tasks that we're speaking about. So what are the monitoring tasks? And while I wouldn't go into any examples, because I see Michelle, hi Michelle, I see that Michelle is also asking in the chat, you know, what kind of computational tools are being used. I wouldn't go into that discussion, because I think that also these computational tools tools that are currently being used are developed with some degree of secrecy, because then they are part of this adversarial environment where you have a market player trying to do something and then kind of find a gap and explore a gap, maybe a regulatory gap or a specific practice that they try to circumvent the law with. And then the regulatory agencies try to catch that or to fill the gap, and so on and so forth. So there's this ping pong. But what I could say is that if you look at very specific tasks, so there is and I think also competition authorities are right now very interested, and this is why we gave the example, and perhaps Jerry can build on this as well, the topic of dark patterns that basically all consumer protection authorities, and I think right now in the world, have gotten to work with some version of, okay, what are we going to do about this problem? For those of you who might not be familiar with dark patterns, so the idea of having interface elements that are supposed to be manipulative and that would change consumer behavior to such an extent that it would be, for instance, under European law, considered an unfair commercial practice. This is a very big problem. And I mentioned this example because it is normally under, as I mentioned, under EU law, it's covered by this UCPD, the UCPD directive, which is unfair competition. So it's a realm where consumer protection and antitrust really will meet each other. But then if we look at, how exactly do you make the, let's say, dark patterns detection transparent and accountable, and how do you measure the harms that arise out of that? I guess my answer would be, it depends on which dark pattern you want to measure. So I don't know if Jerry has some very specific thoughts on this, because I think basically we heard also from Daryl earlier, the idea of doing NLP on consumer complaints, and then, for instance, like looking at testimonials as fake testimonials as a dark pattern would be something different than looking at maybe a sneak into basket, even from the measurement and evaluation of that. Jerry, if you want to build on that, or anything else.
Yeah, so yeah, I think I also want to build a bit on the comment that, shall we investigate Google with their services they use, right? And also something that I think Marichka said about that, all this internal process that exists in companies, because in a way, right, exactly as a computer scientist, when we're designing all these kind of studies that, we're going to study that website and try to measure everything they do, it's like that we are looking at the mirror of the real world, and we are hoping that what we're seeing is a good reflection of what's happening underneath, right? So in a way, it might feel that, why are you doing this? Because in the end, we're trying to get data that maybe already exist, right, in the company. And of course, they have way more data than we do. What I want to say by that is that, yeah, it's not just about maybe monitoring, but maybe take a step back and see, okay, what shall be allowed or not allowed, right? We're talking also about antitrust. And I guess, is a question here, I don't know, should Uber, for example, have access to my battery level? I don't know, and how I'm going to measure that. Or, I don't know, there was this other example, I think from, an Amazon book that was listed for 23 million plus shipping, just because, there were two pricing bots that were, colluding each other. And in the end, there was no, let's say, violation on the algorithmic point of view, but there was like about what kind of data they were using. And of course, right, indeed, when designing the studies, building also on the examples that Katarina mentioned, that you really need to know what you are looking for. Otherwise, it will be like, let's scan the whole web and try to find, okay, what is wrong. So these are important points that we need to take into account on exactly how to design these processes and make sure that exactly in the context of transparency and fairness and accountability, they're not just broken mirrors or wrong reflections of what we're dealing with.
Okay.
Yeah.
Is there anything you want to say?
Yeah, can I add just two things?
Of course. Then I'm going to ask an even more complicated question. So.
Okay, well, brace myself. But two things. I think it's really important to distinguish between which actor has which authority. So to really not confuse the type of monitoring that companies are doing in the interest of, improving their products and services, selling more, being smart about prices, possibly manipulating prices, knowing what competitors are doing, the whole Amazon model of using its platform for knowing what is sold best and then putting those products in the market. That kind of surveillance done by a private company is a completely different situation from the regulator, let's say, monitoring the exact same steps, because the mandate is different, the role they have is different. And so, compared to other cases where if you're a civilian and you're using an arm, and you shoot it at someone, might be a completely different situation than a police officer shooting. So it's really important to keep in mind who's doing what and why. So they're doing it to keep fairness in the economy. They're doing it on behalf of, entire society, whereas a company is acting probably mostly in self-interest. Second thing I wanted to say is that we see a lot of companies hiding behind the argument that they simply didn't measure something. So we see this a lot in disinformation. It's like a convenient way of denying something, simply saying, well, we don't know how many of X we take down, but it's a choice not to measure. And so I think one way to look at it is to say, well, companies know that they can't violate antitrust rules, and they cannot get away with saying, well, we accidentally monitored what you said, Jerry, I don't know, when the fuel runs out in the car, and then we figured out X, Y, and Z. Companies should be held accountable for violating antitrust. But what I can imagine, again, is that there will be standards of how they must monitor their own activities, so that when they're probed for possible violations of antitrust, that they have something to hand over, and that they can't say, well, the machine made all the decisions. We have no logs. We have no idea. It's a black box. And sorry, the black box may or may not have violated the rules, right? I just don't think that that's sustainable in an open market and open society.
Okay, let me come with my complex question. So something we heard today is the need to integrate expertise. And so, of course, it goes both ways, right? So you want to work with computer scientists, potentially not just at the end of it and ask them for the magic tool because it does not exist. It also means that you need to work with lawyers. And it seems to me that if you were just to hire a computer scientist and say, okay, you design and you do everything yourself, then procedural fairness will go down, and this is not what we want. And so if you need to increase your expertise in computer science and to make sure that you have lawyers dedicated to working with those computer scientists, what you need is to hire more, right? And the right persons. And something that Michal mentioned is that, of course, if you are trying to hire a computer scientist versus a big tech companies that may pay 200K a year, this will be a challenge. And so it seems to me that a big issue is the one of money. And you have to be able to put some money on the table eventually, right? You will be able to attract a few experts that may believe that they will increase the common good if they work for the agency, which is true. But for the most part, you need to put the money on the table. And so my question is, I guess, more for you. I'm wondering how would you present that to a parliament? How would you make the point that we need more budget and this budget needs to be allocated to those issues? Is it something that you think is possible? How would you present that? And yeah, I guess that's one of my worries. And being in touch with a few agencies, and by the way, a few of them are in the chat right now, I can see that they are convinced for the most part that computational tools can help, but they may fear that politically it might be complicated for them to go and ask for budget and to hire the right person. So how would you go about that?
Well, so I think one thing that's the good news if you're the regulator is that antitrust enforcement is actually quite a popular thing to do, and it is non-polarizing. So normally speaking, conservatives and progressives, they all agree that you need some enforcement of market rules. So when I was a member of European Parliament, I always felt strongly about not politicizing it. So members of Parliament from time to time would say, oh, break up this company or break up that company. And I would say, well, you know, the authorities have the power to break up a company if they think that it's necessary. I don't have the access to information, you know, et cetera, et cetera. Mm. So that's one thing. The second thing is, of course, that fines in the antitrust context bring in a lot of money. You may have seen the Italian antitrust regulator has just fined, I think, 1.8 billion euros yesterday, and there will be appeals and so on and so forth. But there is a case to be made that some of the financing of antitrust enforcement should simply come from antitrust sanctions. And I'm pretty sure that I'm not aware of the budgets exactly, but I'm pretty sure that what is spent to enforce antitrust rules is already quite significant, because there's also lawyers involved, and you know, antitrust authorities have experts. I mean, they work with strong teams because their case has to stand up against, you know, the bank account of big companies that can hire the best lawyers in the world. And so if it would be me as an executive to make the case vis-a-vis a parliament that we need proper resources, I would not be afraid to have that debate. I think parliaments would actually grant that authority because they see the benefits, and because actually the fines that come in would probably cover all those expenses and more.
All right. Yes, I will just give the floor to you, Jerry and Catalina. I'm curious as to what is your experience with consumer protection agencies and how they deal with computer science expertise. I just want to mention that something that the FTC is now doing, and I think this is excellent, is to say, okay, for each dollar that you spent on the FTC budget, it actually gives back the American people, I think it was $18 eventually. And I think this is very convincing, right? And so, and I know that the French competition agency is engaged in the same kind of studies. And so I think, you know, this kind of arguments, indeed published in the annual report, will be something that I would love to see more, instead of potentially just focusing on the fines, because it may create also a perverse incentive. But what is your take on that, Catalina and Jerry? Have you seen, is it very difficult for consumer protection agency to hire computer scientists? Are they doing it? Are you positive about the future, or are you about to leave us on a negative note right now?
Definitely not going to end the event on a negative note, because I think that there is just only one way ahead, and then that way is basically for a more kind of hybridization of enforcement, where okay, we have these brick and mortar situations in consumer protection and in competition law, but then we also have digital markets, and the only way in which we're going to be able to keep trace, because this is also what you started out with, right? Like all of the data that is available on digital markets, the only way in which we're going to be able to do this at a scalable way is going to be through some degree of automation. Now, the question is how to do this automation in a responsible way, and not in a way, and this is what Jerry was mentioning in the presentation, not in a way where we kind of idealize technology as the universal panacea, and then you know, you get a tool as if you're buying a Microsoft license, and then with that you can just do absolutely everything under the sun in terms of antitrust violations or consumer protection violations. A lot of the technology that we are talking about here today just doesn't exist, and also, and I'm very curious to see also the next days of the conference. I'll be following that closely, but there are a lot of pilots, that is for sure. I think Harry also gave a lot of very interesting examples, but these pilots, basically, they bring together like a set of interests of agencies, and then a set of possibilities that are technical. And we have seen also in our work with Jerry, so kind of marrying these two perspectives is just, it takes time. It really, interdisciplinarity that entails, let's break down a legal norm and try to create a computational framework for that. It's not something that happens overnight. And it's not something that you can go and solve through maybe more, kind of go-to approaches that also computer science has had. For instance, like crowdsourcing, as a lot of labeling is being crowdsourced in computer science. That's not the same with legal labeling. That's very expensive, and we have seen in a lot of different projects that it takes a lot of time to get some serious legal labeling going on. But this is the only way. And in my experience, I've seen that there's a lot of positive attitudes in consumer authorities in terms of getting data scientists on board. The question is indeed how to do that in a way that is not going to create, at least in the European Union, kind of a European Union in two paces, where if there's going to be resources and then you invest these resources in authorities, then you will have the state of the art, at least vision and policy. And then if there aren't enough public resources to invest that and to kind of recreate an architecture, then we might even end up having this type of like forum shopping, where maybe if you do business in some member states, then for a fact that you're not going to be necessarily traced, let's say, online as a company. So those would be some thoughts. Jerry?
Yeah, I totally agree. Just to add to that, right? Two things maybe. One thing is that exactly, interdisciplinarity is difficult, but if I can talk to Catalina and she can understand me, and the other way around, and somehow we can respect each other's limits, then things are possible. On the other hand, like in relation to exactly the budget spending, I think it's just a matter of also how you sell it, right? Because exactly the idea of investing in people and maybe, let's say, long-term solutions might be cheaper in the long term, instead of, oh, I don't know how to do that, or I don't know how to do that, so I need to invest in some procurement tools to give me the AI tools. So in the end, it's also a matter of, putting down the numbers and, persuade the right people. But I think, also based on our discussions with Catalina and different consumer authorities, the mindset has changed. But of course, it takes time also for, to land for good.
Let me ask you a very final and personal question, Jerry. Are you receiving offers from the private sector? Is it something that, are they reaching out to you?
Well, yeah, I wanted to talk about that, right? Because exactly that is always the question we have as also academics, right? When we're looking for PhD students, we can offer them a fixed amount of money, but then the companies are offering way more. So yes, that's always right. That's always happening. But then, the fact that we still have a strong academia in things like data science and machine learning is hopeful that the same way we can have it also in public administration.
All right, so that's the positive note I needed. I see one question in the chat, which in my opinion is quite easy for once to answer by Thomas. Yes, there is a place for antitrust lawyers with NLP expertise. If you are interested in working for competition agencies, just be in touch with them, because I can tell you that they are looking for some. And if you follow me on Twitter and others, you will see that there are lots of advertisements on a regular basis. So I think the main message is not to be a dinosaur, because dinosaurs disappear. And the dinosaur is, for me, the one ignoring all of our discussion right now. And so this ties also to the other questions, which was unanswered. Is pricing algorithm being used right now on the markets? The answer is yes and no. What is being used is companies using algorithms to better collude when they've decided on their own without a computer to collude, right? So what will be the best price? That is being used. However, cases in which algorithms by themselves, whatever it means, decided to collude are actually at the number of 0 right now when it comes to antitrust enforcement. So I hope that I answered all the questions. What I do want to say is that, first of all, thank you very much, Catalina and Jerry. Thank you also to all of you who stayed online so late, for those of you in Europe, as we are. Tomorrow, same time, we will dive into different projects in which they used computational tools. So it will be also answering quite a few questions that we had in the chat as to what, from a very practical point of view, you can do. They will be showing you how to use it for better enforcement or to analyze the case law. They will be explaining their results. Everything is open access. And so this will be a way for you to reproduce their methods, which I'm sure will be helpful to all of us. So with that, this is the end of day one. I'll see you tomorrow, same time, 5 p.m. in Europe. And take care. Have a great night. Bye-bye.